before the
It's Janet Toot here. I'm terribly sorry, but you're very there's tremendous feedback at my end.
Janet appears to be asking for feedback to her end.
If she could remain muted until she's asked to join the meeting.
Okay. I'll just say a list with the protocol. All visitors must sign the visit book and the entrance to Kilcrease. This includes council staff from other buildings. There is no planned fire evacuation drill or alarm test today. If the fire alarm is activated during their visit, you must exit the building immediately. Council officers will direct you to the nearest fire exit and will escort visitors to the building fire assembly point beside the silver lamp at the top of the Parliament Walk. Kilcrease staff should report to the floor's assembly point. You should remain at your assembly point until directed to reoccupy the building and only re-enter once the fire marshal has advised it is safe to do so. Please do not attempt to leave the site by vehicle until cleared to do so by the fire marshal to ensure access are kept clear for emergency vehicles. Please note that this is a public meeting and that members of the public may be in attendance. The meeting will be recorded by the clerk and published online for public viewing. The taking of photographs, including screenshots, audio or video recordings are not permitted during the meetings unless they express permission from myself. Can members attending virtually activate their cameras where possible to enable you to join by video, and can all attendees mute their microphones when not speaking. Please do not come in during the item unless I invite you to do so. If members attending virtually wish to speak on any point, please indicate by clicking on the raise your hand button. Members in the chamber should also raise their hand. I will bring you in at the appropriate time. If members have not been able to access all papers for the meeting, please indicate. Now, as a clerk, to take the roll call to confirm attendance at the meeting, I would ask that members indicate if they wish to declare an interest.
Thank you very much, Chair. So we've got Councillor Lee in attendance, Councillor Lindsay sends his apologies, Councillor McCluskey is here, Councillor Basili is here, Councillor Benny has sent her apologies, Councillor Keogh is here, and Councillor Locke is here. We are on it and somebody wants to declare interest.
Okay.
Councillor Keogh?
Yes, aim for part 3, application for the
Okay. Right. So the protocol is that when we get to that item, that you will remove yourself from the meeting to allow that item to be discussed and voted upon, and then we'll bring it back in the paper.
Okay. Thanks, Chair. Move to item 3 on the agenda, which is the minutes of the meeting held in the council chambers on Tuesday, 29th of August. Page 5 of the papers, page 6, page 7, page 8, page 9, page 10, and page 11. Is that true? And that's the record of the minute of the meeting. Good. Okay, we'll now move to item 4 on the agenda. First one is an application for Clackmannanshire Golf Club. I believe all you have you're going to speak in the report.
So I was expecting Sean to do the introduction in the matter. In relation to the application for Clackmannanshire Golf Club for the occasional licence, I would like at this stage to formally withdraw my representation in relation to the matter. An amended application has been received that meets the criteria for an event that could be granted under delegated powers.
You speak it to the microphone.
Sorry, is that better? I withdraw my representation in relation to that application. An application has been submitted that is an amended application that meets the criteria for an application for a catering licence that could be granted under delegate powers. There's no longer any concerns after discussion with the applicant.
Thank you. So to confirm, that means that the application has been withdrawn, yeah?
Yes, the application that this matter relates to has been withdrawn and has been replaced by an amended application, which we process, the licence team will process independently and has been granted under delegate powers, or will be granted under delegate powers as the matters of concern are been suitably amended.
Okay. So we get that. The second application is in the name of the Golden Inn. I believe we seem to have Ms. Hood online to speak to this one. I realise Paul, you'll speak to the first.
Yes, I can confirm that the sound quality isn't great at the other side for Janet Hood, and I can confirm on her behalf that she represents the licence holders in relation to that matter. Again, this is I know it's a last minute matter, but I would like at this stage to formally withdraw the application for a premises licence review. The matters raised in the review application have largely been addressed by a transfer application that successfully transferred the details of the licence holder to another individual who has eased the concerns, let's say, that I had about the specific premises licence holder, particularly the very remote nature of the licence holder, the original licence holder being a company in London that were very difficult to engage with. So that's now been, that licence has now been transferred to a local individual who will take on the responsibility of the management of the premises. I'm satisfied that he is a fit and proper person at this stage to manage the premises. He's certainly in a better place to manage the premises, and coincidentally he's also named as the current premises manager. So he has a full reign of responsibility, he has full accountability across all matters connected to the premises. We've also reached agreement with the solicitor about a management plan, the representing solicitor about a management plan for the premises going forward that addresses some of the administrative concerns that are raised in the review application. And as such, at this stage, I'm comfortable that I can withdraw the review application. Notwithstanding that, I would obviously hold on to both the power and the right to resubmit the application using some of the similar terms, because it's not being considered by the licensing board in the future should matters not be amended, however, or the improvement, the improvement method has not been reached. However, I do expect that will be the case going forward, and we can start with a new licence holder with a clean slate and work towards becoming a successful and regular business again.
Thank you.
Thank you very much, Convener, Your Honours. Excuse me, I've got a bit of a cough. I was absolutely horrified when I read the review application. I immediately contacted Mr. Fair. He has been so helpful, it's been beyond belief. There seems to have been difficulties in communication from my predecessor in the firm that I'm representing at the moment. I'm representing as a consultant. I am delighted that we've managed to come to a working conclusion. I'm working with my clients and Mr. Fair to make sure that matters go forward properly. We know that there have been breaches of licence legislation in the past, and that is why when Mr. Fair suggested that we do a transfer to an appropriate person who's in the area, in fact the person lives directly opposite the premises, that this would help solve almost every problem that we have been facing. The owners of the premises have been advised that they need to keep in touch with the premises, that they do have to understand that they have duties as well. I will be supplying all the information Mr. Fair needs with regard to interested and connected persons. I have no explanation why this has not been done in the past, and I can't answer for the actions of somebody else. But what I can say is that Mr. Fair and I have worked together on a number of matters over the years. We trust each other and will be able to push forward. I do hope that you will accept Mr. Fair's removal of this review application, look positively to the transfer, and we can move forward into a brighter future for the wool pack. Thank you very much for listening to me.
Thank you. Member, do you have any questions?
I just want to really know what the level of scrutiny is going to be going forward, because what's to stop this happening again if there's more transgressions in the future, they just simply pass it over to another fit and proper person and they just run down that rabbit hole each time. So I just wonder if there's any extra scrutiny in place to really keep an eye and make sure we're crossing the T's, dotting I's.
Yeah, I can pretty much guarantee it will be closely monitored. It will remain on a monitored list in terms of licence and compliance. There is work in place to, you'll have seen, if you've obviously had the opportunity to read the review application, some of the matters relate to the installation of a radio station in part of the lands that has no consents and permissions. There's work going on in the background to ensure that that's all appropriately consented for, building orders and planning, which are obviously not a licensing matter, but in terms of the licensing matter that's concerned with. There's also, I've recently viewed the finalised drawings to have that particular area removed from the licensed footprint of the premises, so it's no longer something that should have been done in advance of the works being carried out, but again, it's something that is now well on its way. I understand that there will be an application to vary the licensed footprint of the premises in the very near future. So that's obviously progressed. In addition to that, the premises manager that is currently in place, he is now the premises licence holder, very experienced individual. He runs another premises, or is involved with another premises that's quite a significant premises. He's been involved in the trade, the hospitality industry for many, many years. I don't expect that he would want his personal reputation tarnished by what goes on, because his involvement with other businesses is far more significant than what he's taken on with the road pack. But of course, it will be subject to more frequent visits, compliance visits, than probably any other premises in Clackmannanshire, as you know. In all the years I've been here, I don't take very lightly the submission of a premises licence review application. The board with law had to read very many submissions of that nature for me over the 15 years that I've been here. So no, it was an absolute last resort. There was no going back from it. And now that we've reached, there's a proper management plan in place, which, you know, there's a few things just to be tidied up with it. I expect going forward, I'm not concerned that the level of scrutiny will cause that. Okay, and there being no doubt, the threshold for returning here would be much shorter than what's happened in the past. These matters are spread over, you know, a 2-year period plus, as you can see. The threshold for returning to another review application would be a much shorter period of failure and compliance.
Members, do they any other questions?
Paul, I need you to be as crystal clear as you can about this, because a lot of the documentation that we have before us about the roll pack over the last 2 to 2.5 years provides quite a lot of serious breaches, as well as the inability to identify who the licence holder is, and indeed to the business premises. So my question to you is, are we now clear who the actual owner of the premises are, who the appropriate licence holder is? And thirdly, that I know you were saying it's, well, I feel it's material to the application, that there was alterations going on in the road pack which hadn't been approved by planning in relation to a radio station. Have these issues been resolved at an officer level in the applicant to your satisfaction, to enable the recommendation? Or well, so if you can update me in the current situation as it is. as it is today in terms of this application?
So obviously we'll start in a sort of reverse order in terms of the planning application, the planning matter and the building one matter. It's obviously not a matter for me, neither is it a matter for the licensing board, but I can assure you that the planning building standards team leader is aware of the situation and is definitely monitoring matters going forward. There has been, my understanding is that there has been a site visit made and they are the owners of the property are aware of what requires to be done in terms of taking that matter forward. And I feel certain that will reach a conclusion because there's other issues in connection with a sign that's been erected on a wall outside and things like that that you may be not felt locally that will be addressed. I expect that that matter will be properly addressed by council officers and the appropriate departments. In terms of the other matters, it's a matter that's well raised in a conversation had with Ms. Hill on Friday. I think it was. There is an agreement in place that as soon as this matter is resolved today, I will formally write to the new licence holder and require them to provide me the details of the current tenants who would be interested parties. And therefore we have a full chain of who's responsible, who holds a licence, who's responsible for the day-to-day management, and who's responsible for the behind-the-scenes decisions in terms of the financial interest in the business. Something that we often don't have for tenanted businesses. We often don't have access to that interested party information because we're just simply not aware that it happens. In this case, because we are aware of the arrangement and the tenant, the arrangement of the tenancy, we could make the request to the licence holder to provide us the information about the tenants as the formally interested parties in terms of licence in Scotland. So the legal requirement for them to disclose that information. And Mr. Davis, of course, expressed a willingness to provide that without any need for any formal process to obtain information that we will hand it over as soon as this matter is laid. And that leaves us in a very good position to understand who's responsible for what at the premises.
And I don't mean to appear a bit dim, but there's a number of names mentioned here. So who is going to be the named licence holder then in your information?
The licence was transferred to Andrew Meekie. Andrew Meekie, who is he operates a business outside, so he's involved or connected with a business outside Blair Athol. It's a long established business. He's been 20 years in the hospitality or perhaps more. I think he's a personal licence holder with no adverse comments about it. He came across very well, just as an aside. He does not really match quite a lot to me in terms of first impressions. I engaged with the telephone for quite a significant period of time when his name first came in before for that. And he comes across as being an individual that clearly doesn't want his own personal reputation tarnished by any connection to things that have happened in the past, and he's only interested in moving forward, which I think is the right way for this premises looking forward. I think, on a personal note, you sort of both remember that it was a very well-run premises. It was probably a little gem in the heart of therapeutic, and it's sad to see that on an individual basis lost to what it's been more recently, and hopefully at some point in the future that can be revisited.
Okay, thanks, Chair.
Okay. Are there any other questions? Okay, as I say, this application, the original application for review has been withdrawn, and they're asked to support the this new application by a new premises licence holder. I've read through the papers on this one. I'll be honest, I mean, when I first read it, I thought, well, does this mean that the previous persons that this original report referred to have basically said, well, I've got away with it, I've done all the concerns that were raised by the police and the LSO in the past seem to be just swept aside. And a member of the public looking at a report of this would think, well, what's been done? It just seems to be that they have done what they've done and gone away with it. I'm concerned with that. Oh,
I think the minutes of today's meeting hopefully will reflect the fact that we haven't withdrawn the review application lightly. We should, I suppose, as a licensing board, bear in mind that the purpose is to ensure that premises are operating in compliance with the licensing objectives going forward. It's not a punitive exercise, a review application. It's a matter to see if there's anything that needs to be changed going forward to prevent reoccurrence of things that have happened in the past. We Scotland obviously have and have had the opportunity in the various offences that have been committed to make a decision about whether or not to prosecute individuals and they've chosen not to. That's a matter that's where the punishment element could have been picked up from the wrongdoings. We Scotland very much in agreement, as I'm saying, we're not here at this moment in time, that's happy with us. But Police Scotland are very much in agreement that this is the approach to the matters that have been raised are better dealt with the licensing board rather than through the criminal approach process. The difficulty being, of course, if a London company, which is what's described as a dominant company, the only purpose of that company existing is to hold the licence. My understanding, the understanding of the company law, they can dissolve that company tomorrow if it's only holding a licence, and the company would be the criminally liable organisation for any crimes or offences that have been committed in relation to the licence in Scotland. So the company could be convicted, be fined and dissolved tomorrow, and you would have exactly the same effect as we have today. I don't think, if I can perfectly satisfy this mechanism, I don't think the transfer has been done to avoid any potential sanctions. I think the transfer has definitely been done to address the improvements that are required and that are recognised. I'm certainly satisfied that that is the case, or we would have had the opportunity to be suspicious of the motive for the transfer. We would have had the ability not to grant that transfer the right way and hold the hearing first. But I'm perfectly satisfied, as Janet has said, we've known each other for a long time. We've been in this circle between us for, this particular circle for 15 years each, and much longer. In Janet Hood's case, we're in a place where there is an element of trust that's been built up over the years. So I think to answer the question, yes, it appears like they have just got away with it, but that was always a very good likelihood anyway, because the outcome could have been, regardless of what was said, the outcome could have been that they took action that avoided any sanction, and the difficulty would have been is when you've got many assurances that going forward these things that have happened in the past won't happen again, coupled with a recognition that they have been wrong, coupled with a recognition that individuals have made mistakes and they are no longer in the process. It's very difficult to then say going forward that it's necessary to revoke the licence or suspend the licence, because the purpose behind that would appear to be potentially punitive, and that's not the purpose of the Licence in Scotland Act and the review process. The review process is all about ensuring going forward we're in a good place to continue, trading lawfully rather than where we've been. So I think I'm satisfied that the process has not been done to circumvent any potential sanctions. Had I thought that, I can assure you we sit here with a different approach, begging the licence board to continue with the hearing and hear all the evidence that is there about the wrongdoings. So I hope that answers your question. And again, the public nature of the licensing board hearing today, the reason it wasn't withdrawn last week, 2 weeks ago, when we potentially knew it could have been withdrawn, was to ensure that there's a public record of the discussion that's held around the withdrawal, which obviously the public can view. They can hear everything that's being said today, they're entitled to access everything that's being said today. So the transparency matter is there. We can see why we've reached the stage we are and have an understanding if we watch the video or they see the copy of the video or even look at the minutes.
Thank you, Paul.
So I just want to clarify, so what we've got at the moment is this premises review application has been put forward that currently the licensing standards officer is withdrawing based on the reasoning that you've provided today. I just want to make sure that the members here on the board are aware of that and basically hand over to the decision to the chair to confirm that we're happy with that.
So the application has been withdrawn.
Yeah, the application for review has been withdrawn with a view to the due diligence is going to be done based on the discussions that have taken place also with Janet Hood and the licensing standards officer and the licensing team.
The new application.
The application will be presented to the board, is that correct?
The application to vary the licence, there's still a small amount of discussion to take place about what that application is going to look like and whether or not it meets the criteria for a minor variation or a non-minor variation. Of course, if it's a minor variation, it would be granted under delegated powers because we must grant a minor variation. If it's non-minor, it would of course come before the board. But the transfer application is already complete if that's the application that you're speaking of. It went out for consultation last week. There was no objections or representations made by any party and therefore was granted under delegated powers in accordance with the terms of the Licence and Scotland Act and the scheme delegation.
Okay, thank you. Members happy with that? Okay. Okay. We'll now move to application 4.3 on the paper. An application in the name of Wellness Games.
Councillor Keir, Councillor Keir, we'll make sure that one of the officers comes and lets you know what the decision will be.
Can I just say, on behalf of my clients, thank you very much for your decision, and I can assure you that my clients will be working with Mr. Fair moving forward into the future, and we're very grateful to you, and I hope you have a super rest of the day. Thank you.
Fine.
Good morning, everyone. So, item 4.3 is an application for a personal licence that was submitted and has attracted a representation from the Licensing Standards Officer, which Mr. Fair will go through with you.
Just for the purpose of the minute, I think we've already been noted.
Can you speak directly to the microphone?
Yes, for the purpose of the minute, I think it's probably already noted that Ms. Williams, the applicant, has indicated that she's unable to attend today. So the application relates to our first application for a personal licence for an individual called Clackmannanshire. The committee will have obviously, the board will have had the opportunity to see my report and perhaps digest the content of it. It's not an extensive report. It really concentrates on two matters of importance, and it will become fairly obvious in reading the report that the board will realise that it's connected to the matter of the Rollpack Public House where the review application has been withdrawn. However, the conduct of certain individuals may well come before the board in the future, and this particular individual is connected to the Rollpack Public House. Ms. Williams, my understanding is, and I've had sort of verbal confirmation, is one of the tenants that took over the Rollpack sometime around about July. Not certain of a date yet, that's yet to be confirmed. However, around about the same time as Williams, the intention was that she would be nominated, I'm told, as the premises manager of the Rollpack, having taken it over along with her partner. And she completed a Scottish Certificate for Personal Licence Holders course on the 31st of July. That course is a very detailed course. As I'm sure you're aware, we've discussed the content of the course on a number of occasions. It includes significant input in relation to the role of a personal licence holder on licensed premises. It includes a significant input in relation to the licence documents, the premises licence, the operating plan, the layout plan. Because when you're granting a personal licence, you're also granted the right to deliver training to other staff members who are not personal licence holders. So it covers in detail the requirements of training, the mandatory 2 hours training for everybody that works on licensed premises, and the capacity for making sales or service of alcohol are required to complete. And it covers in quite some detail the role of a premises manager, the requirement for a premises manager of licensed premises, and the circumstances where the sale of alcohol must cease when no premises manager exists. In this situation, Ms Williams appears to have worked on the licensed premises from around about July. Again, my understanding is I'm not quite sure of the date when she first took up residency or tenancy there. And she certainly lodged an application for a personal licence on the 15th of August, and by that date she was certainly working on the premises. At some point in mid-July, information was provided that Ms Williams and a partner had taken over the road park and that she was operating the premises and training premises. Inquiries were obviously ongoing into the road park at that time in relation to a significant number of compliance failures that were going on in the background, and that came to a head on the Thursday the 31st of August 2023, where I carried out a joint visit at the road park along with an officer from Police Scotland that was actually Sergeant May from the licensing team. On the day we went in, we met with an individual who identified himself as Stevie Mack, and at one point during the conversation he conceded that he was the partner of Miss Williams' applicant. However, made it very, very clear that he had nothing to do with the licensed premises. He was just a handy, described himself as a handyman carrying out tasks for Miss Williams. We had a discussion at that point about making contact with Miss Williams and asking her if she could be given contact details, and he explained to me they had no means of getting in touch with her at that time. We left the premises, made further inquiries. I think Sergeant May shared my thoughts at that time that the individual Stevie Mack was bordering on being obstructive. However, in the circumstances where he claimed he had no connection whatsoever with the licensed premises, of course there was no legal requirement to assist me in any way. If, as it turns out, he was an interested party, and I'm awaiting that confirmation that he definitely is, as a joint tenant, for instance, then he would be under an obligation to assist the licensing standards officer in making any information and assistance as he could. Now, having looked closer at the information held on the licensing files, on Friday the 1st of September, we were satisfied, I was satisfied, that there was no premises manager in place for the road park, and therefore the sale of alcohol could not take place. We established that a date in June would be the date in which the premises manager, the previous premises manager, had left the premises, and as such, and we had no formal notification from the premises licence holder, which is now conceded by the licence holder, with no formal notification from the premises licence holder that that premises manager had left. Having left, and without the formal notification being received within 7 days, the sale of alcohol at the premises must cease immediately. So they had no legal ability to make sales of alcohol from a day around about mid to late June. We're not absolutely certain of the date I have. I think we'll be in the review application, maybe it'll be the week before the 24th of June, but it's somewhere in that area. But it's neither here nor there. Certainly by the 1st of August, sorry, by the 31st of August and the 1st of September, there was no circumstances in which they could legally continue to sell alcohol. The remedy for that is that it amounts to a breach of a mandatory condition of the licence, which states that no alcohol can be sold in parlour is no premises management place. I have that conversation on Friday, the 1st of September, with Ms Williams, and make it very clear to her that the circumstances are that a compliance notice would be served later that day. It would be left at the premises and sent to the then premises licence holder, an email address I had in London connected to the individuals in London that held the licence at that time. Made it very clear to Ms Williams at the telephone conversation that the consequences of failing to comply with that notice could result in criminal charges, could also result in a premises licence review application being made, and could have consequences for the personal licence application. The notice was served in the afternoon at the premises, and it was acknowledged as having been received by Ms Williams in the conversation that we had. Having received information later on that day that the premises were in fact open and in full swing, I made contact with Police Scotland. Two officers from Police Scotland, I believe, at around 10 PM. And on arrival, they found the premises were under the control of Ms Williams, the applicant. There were 20 to 30 customers, all with alcohol were on the premises, and that Ms Williams conceded to the police officers that she and another staff member on the premises had made sales of alcohol. So I should add that in the previous conversation with Ms Williams, she conceded that she had been making sales of alcohol on the premises since she took over in July. Ms Williams has no training record, which in the absence of a personal licence she is required to have, even though she has a higher standard of qualification. She's still required to hold that training record until the personal licence is granted. And the other member of staff that was present on that night was also unable to produce any form of training record. Ms Williams said that she was acting under her instruction as the tenant of the bar. I think in all the circumstances, I have difficulty seeing past a conversation that I have very, very clearly with an applicant for a personal licence who's very recently qualified, who's very recently done a course and passed an exam that makes it very clear that she understands the law and the legislation around it. And in addition to that, there's a very clear conversation about the potential consequences. I have difficulty, even though the premises licence review application has been withdrawn, there is still a liability on this individual who I would now have great concern about if she became the premises manager tomorrow, if her licence was granted today. My position is very, very clearly that because of her behaviour on the day and in the build-up to this application being lodged, that she's made sales of alcohol, and on the night in question, we were within hours of a compliance notice being served that instructs that no further sales of alcohol be made on the premises, that she continues in defiance of that notice and clear breach of that notice. But she understood, and no doubt whatsoever from the conversation, she understood what that notice meant. That she continues to make sales, and her position is very clearly that she is not a fit and proper person to hold a personal licence. I have great difficulty in having any trust in an individual that breaches a very, very clear instruction within hours of that instruction being made, with no explanation or offer. I mean, she's aware of the terms of this report. She's had the opportunity for some 3 weeks now, or thereabouts, I would expect, to compose some sort of response. I understand that no response has been made, no explanation of her conduct is made, and she's not here today. I would ask the board officer not to put any weight on her not being here today, because that may well be a matter that's out of her control. However, the lack of any other formal response, the lack of her inviting someone to come and represent her, is I think something that on balance of probability the board would be entitled to take into consideration. I'm happy to answer any questions. I don't think I've got anything further to add, other than making it very clear that she's already done. My position is that she's not a fit for the person to hold a personal licence. I should also make it clear that if the board agreed with that submission and refused the personal licence, it will be a year before she's entitled to reapply for that licence, and it would not prevent her working on licensed premises. I understand that she now does have a training record. The new manager, the new premises manager that discussed in the previous matter, has trained all the staff and provided training records, complete training records for each. So it wouldn't prevent her from working on the licensed premises. What it would prevent is her being the premises manager for any licensed premises for the next year. And prevent her obviously applying for or delivering training or applying for a personal license. Happy to answer any questions.
Thank you, Paul. Can I just get some clarification from the clerical staff? Have we had any contact from this prior to the meeting?
Chair was explained by the Licensing Standards Officer that she's unable to attend today.
Thank you. Thank you. Members, do we have any questions on this one?
Chair. Just to clarify some of the points made, were there any explanations given forthwith from Ms. Williams' statement in relation to her conduct? You know, it states quite clearly that the major breaches on several occasions, and then typical points 22 and 23, a complete disregard for, you know, Elena Kevin herself to explain the position, in her position to then go ahead and serve customers anyway. You know, is there any explanation given from that to that point at all?
There's been no such explanation provided to me or any members of the licensing team, as I understand that. There's no communication since she was served with us, and I think perhaps shall we be able to confirm that the notices were sent out within the statutory timescale. I think since the service notice, the only contact we've had is an indication that she's unable to attend with no accompanying explanation. My understanding is I've seen the operational statements from the police, and there's no explanation contained in that for her breaching the notice. The only person that could offer the explanation would be Ms. Williams. It would be unfair of me to introduce any comments that she makes to the police officers in relation to why she was open or otherwise. That's a matter that she should have presented to the licensing board rather than, or even through me. I said it explains at the time that, you know, when she was made aware that the application for a personal licence was attracted to the report because of her conduct. She was given the opportunity to speak to me, and I would have included I would have any explanation. You can see this before, there were any explanation she wants to have. There was nothing.
So, further question. I think from the report, showing Ms. Williams got a licence at the end of July. Given such a short period of time has elapsed, and there have been a number of breaches from that point, I would just say it's a year, and then she can apply again, or she needs to go back and do the training. I'm not really sure how that works.
At the moment, she doesn't hold a personal licence at all. This is an application assist to determine her application. And it's the first, it's an initial application, it's not a renewal on that. So this is what the purpose of the hearing is, to determine her application of whether or not they grant or refuse the licence. So the moment she has no licence, if she's refused the licence, the legislation states that she cannot reapply for a period of 1 year unless there's a significant change of circumstances that she brings to the attention of the licensing board. She can seek for that period to be shortened. and at the moment, because of the review status of the qualification, the personal licence holder's qualification, which she completed in July, that's the matter that's done now. She would not have to redo that qualification because it's not due for a review until I think 2024 would be the next review. But the current qualification would probably be lapsed and the new qualification would be introduced, and therefore that would take out. So she wouldn't have to redo any training course. My understanding that could have of course changed because we got the first round the corner with the Scottish Government Register programme. That could have of course changed, but it's unlikely my view is
Mark?
So just a small point of clarification, Paul. When you served the section 14 notice, was she actually on the premises at the time?
No, because the notice is served on the premises and licence holder. She was nothing more than an individual that had a remote connection with the premises on the day in question. It's coincidental, obviously, that in the background she has an application for a personal licence, which she had no, at that point, we were unaware of any formal connection because we've not been through the formal process of asking for the notifications about the interested parties. I mean, it's something that the good premises licence holders, or the better organised ones, notify you anyway, this particular premises licence holder. We can see the difficulties that are going on in the background there, so they have, so we were unaware of an interested party connection. So the notice, the section 14 notice was left at the bar and sent by email to the premises licence holder. But however, in absolute fairness to Ms. Willows, because of the suggested connection that I was aware of, the discussion was had with Ms. Willows because it was, I felt that it was unfair not to have that discussion with her and make it very clear to the consequences.
Yes, thanks. I can answer the next question. Just when you mentioned that she acknowledged receipt of notice, I was just going to say, was that a verbal acknowledgement, like a telephone call or something?
Yes, the conversation was after the notice was sent.
Okay. Any other questions? So, and this one here, I understand where the questions. I understand the questions that were on that were made by Councillor Lee. In fact, I could put the same items to bring myself on the very fact that I noticed had been served. This person was aware that, but she made a statement to say that she wouldn't be serving alcohol. Am I correct? If I understand right in the report?
Where would not be serving?
Yeah, this will understand me that the premises will not open on day or for the rest of the weekend.
Yes, that's exactly correct. That was on the receipt of notice. She says, yes, I understand that. We won't be open today or for the rest of the weekend. She goes further on, I've not included it in the card, but she goes further on to explain, I'll get in touch with the licence holder. Now, at that stage, she was even aware who the licence holder was. She spoke about individuals in another area and not being entirely certain who the licence holder is, which goes back to the issues with communication with the previous licence holder. She said she would get in touch with the licence holder and she expected that their solicitor would sort this out, quote unquote, before, the following week. But she made it very clear that she understood the consequences. She indicated that she had no intention to vote now, and that the matter she would open until the whole matter was resolved. Clearly something changed.
So the premises were open tonight, serving alcohol, but we still didn't have a premises manager on the premises at the time.
Yeah. Yes, that's correct.
The other point is the training with us. Now, you rightly say she just went through a course of term involved training the day before, and you could produce a training record the following day. Is that correct?
Just as there was no training because there was no training that could carry out.
So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no training record for members and staff at all. So, no trai This is such a mismatch here of this various of beaches. We've been asked here today to consider whether this person is a fit and proper person to have a personal license, or a promoted personal license. I think the evidence from the papers is so obvious that to my mind, this person is clearly not a fit and proper person. So have no intention of abiding by the contents of the Licence in Scotland Act. Despite assurances not being given to us, despite the opportunity being given to this person to contact the licensing staff for any assistance, any inquiries, they've done absolutely nothing. They've done it, they went ahead and done their own thing. To my mind, this person is not a fit and proper person to hold the licence, and I would ask for a second of this. Councillor Lee.
Thanks, Chair. Yeah, I'm happy to second what I've read. Very confusing set of circumstances, but as a manager, you have a responsibility, especially with the sale of alcohol, and for it to get on this far, and for this many misdemeanours to occur. I agree with Councillor Earl that the staff think it's not a fit for the person to hold it.
No, I was just going to add, I mean, I think that the fact they've just been through the personal licence holder training, which obviously covers everything, I just can't understand then the thought process, then kind of act in the way that they have done, and clearly, obviously, no Paul did go out and speak to her, explain the kind of the rules and regulations, which obviously she's been through the training, she's been clear, and then to go ahead and then serve alcohol on that night, which the police attended. There's just kind of no questions in my mind with the course of action that we need to take here.
Thank you. Yes, Chair. Obviously, in terms of natural justice, it would be good to hear from Ms Williams, but from the papers that we've seen here, as well as the previous issue we discussed, there's really quite an extensive backstory going on there. So, from the papers that we have here before us in terms of the actual case, and indeed the previous paper, there's clearly quite an extensive backstory going on, and I would have liked to have heard from Ms Williams herself, but I have absolutely no reason why we should not accept the recommendation from our own licensing officer that Ms Williams is not a fit and proper person, and therefore we should not issue a licence. Okay, thank you.
Well, I think that that's unanimous. Yeah. Okay, thank you, Councillor. You can run back in if you want.
Malcolm Maisie has been conceded.
Is it Alexander?
Settled? You need to talk about? Okay, we're now going to item 5 on the agenda, which is the Chief Constable's report. I believe we have representation from the Police Scotland today.
Yes. Yes, good morning. Can you hear me okay?
Yeah, yeah.
Good morning, I'm Alec Captrick, I'm the Community Inspector for Clackmannanshire, and I'm here today to present the licence report on behalf of the Chief Constable. Everybody hear me okay? Yeah? I'm not hearing you just now. I can see you're speaking, but...
Sorry about that, I don't think the sound quality is all that great in the room. Could you just give us a minute, Alexander, so we can look at the make any difference by putting the volume on a little bit?
No problem.
You mute this room when you're speaking, so I'm just about to put the volume up, so hopefully we can hear you.
Okay, ideal. I'll start again. Is that good? Yep. So, good morning, I'm Alec Captrick. I'm the Community Inspector for Clackmannanshire. I'm here today, this morning, to present the Chief Constable's licence report for Police Scotland and take any questions which you may have on the report for the period under review, which is 2022 to 2023. I don't propose to go through the report in great detail, but I will highlight certain points, and if anybody wants any questions or any points of clarification, please ask at the end. At present, there's 134 licensed premises throughout Clackmannanshire, and I'll just highlight, to put this in perspective, for last year, there was 608 cases of violent crime recorded within Clackmannanshire and 401 cases of disorder. What I will say in terms of that, from the previous year and from what's under report just now, the 608 cases of violent crime is actually down 42 on the year prior to that, and the 401 cases of disorder for the period under review is also down. That is down 138 from the previous year, so some good reductions there. In terms of the offences linked directly to our licensed premises, there were a total of 56 cases of violent crime and 26 cases of disorder in the period under review 2022 to 23. In terms of the previous reporting year, both those are up marginally, but that can be attributed to the easing of COVID restrictions in 2021 and people returning to licensed premises. So overall, I believe that's a really positive picture there. We continue to carry out proactive licensed visits to our licensed premises as part of our weekend policing plan, and under the period under review, we conducted 367 proactive visits to licensed premises, including off sales and our pubs, etc. And that is up 78 from the previous year as well. I believe that's an important factor in when dealing with disorder and antisocial behaviour at licensed premises. Police going in, offer reassurance and speaking to staff as well. During the period under review, there were no monitored or intervention plans put in place for any licensed premises within Clackmannanshire. And we continue to work in preventing the sale and supply of alcohol to children or young persons. As we're all aware, it can have an extremely damaging effect, which may result in antisocial behaviour locally and have a negative impact on our communities. And over the reporting period, there was one charge relating to buying or attempting to buy alcohol for a child. Our local community officers linking directly with children, educating them into relation to potential dangers of alcohol, along with our prevention and interventions department, who work throughout the community and deliver presentations to young people and raise awareness of that. And whilst out in patrol, officers that come across any children or young people under the influence of alcohol, this information is shared with our partner agencies, for example, health, social care and education, to establish the root cause for these behaviours and eliminate further offending. And as a result of that, the percentage of criminal activity in and around licensed premises involving children is negligible. So for the year ahead, we will continue to work alongside our partners in the Licensing Standards Officer, Environmental Health Officers, HMRC and Trading Standards to ensure frequent visits to the premises are carried out to deter and prevent any antisocial behaviour or disorder or violent crime at these premises. I would just like to touch briefly on the stats there I mentioned earlier. cases of violent crime and disorder associated with licensed premises. As you can see there, for the cases of disorder, there was 28 at licensed premises, and that is obviously 7% there of the total. And again, violent crime 56, and that is just over 9% of crimes there for the total there, which is positive to see. And as you can see from the final table there in the report, or disorder at licensed premises, 26 of the previously mentioned, a really strong detection rate there of 89.7%. And again, for a violent crime at licensed premises, 52, and again, a really strong detection rate of 92.9%. So some really good work going on there with identifying the perpetrators of those offences and bringing them to justice. What I will say is, if anybody is charged and arrested for any offences on licensed premises for violence or disorder, they'll apply for an exclusion order to the court when they go to the court, and it's obviously up to the sheriff if they grant an exclusion order preventing them from entering certain licensed premises, and that is routinely done when people are identified for offending on licensed premises. That was the main things I wanted to highlight from the report. I'm happy to take any questions or answer anything in any further detail if any of the members have any questions. And hopefully you heard me okay.
Thanks, Marina. I hope that you hear me okay, Inspector. Many thanks for presenting the report this morning. And whilst there is a number of really positive reports and figures in it, if I can draw your attention, please, I think it may be page 5 of your report, it's page 76 of our paper. The first paragraph towards the top of the page, which says, "Worth noting there were 3 charges in relation to persons consuming alcohol in a designated public place." Do you confirm that across the whole of Clackmannanshire, therefore that figure means that by whichever means it's possible to dispose of it, whether report to the Procurator Fiscal or by means of an expending list, only 3 persons were charged in the entire 12 months?
Yes, that's correct. Certainly by the figures there, it has only been 3 persons over that reporting period, and I believe previous reporting periods it's always been single figures as well. I don't think there's been any more than the single figures, but yes, I can confirm that is 3 for that reporting period.
Last year, this board made a fairly vigorous response to Chief Inspector Marsh regarding this aspect. Previous reporting period, if I remember correctly, was 10 charges, and given the extent many members of this board expressed their displeasure at that figure, I would have hoped that this report would have come back with a significantly higher number, not one that was greatly reduced. Can you, by any chance, attempt to explain why the detection rate is so low?
Sorry, in terms of detection rate, he's talking about the issue of tickets in relation to drinking in public, is that correct? It's so low.
Yeah, that's correct. Why in 12 months in the whole of Clackmannanshire, the detection rate for consuming alcohol in a public place was only 3?
Certainly, from my knowledge, obviously it was raised at a licensing board last time that Chief Inspector Marsh attended about drinking in public, and if I remember correctly, I think it was particularly in relation to Maple Court in Alloa, which had been identified as a problematic area. Since that last licensing board, in response to that, there has been increased police patrols and presence within Alloa Town Centre and to target drinking in public, particularly at Maple Court and that. So one explanation could be that because there's been an increase in police presence, that has deterred people from drinking alcohol in public. I'm aware that these offences might take place when police aren't always present. We've obviously been really impacted with resourcing over the last year, which has seen our community officers abstracted to cover response policing at times. So that will take away, and drinking in public is predominantly a proactive activity which the police pursue. So in terms of the prevention patrols and community being abstracted from the local communities, I think that would be 2 contributing factors in relation to the lower figure there.
Okay. Any other questions?
Yeah, I was just wondering, the licence offences that relate to buying or attempting to buy tobacco, does that also include vape products that contain tobacco?
Sorry, I didn't catch it. I just got vape products at the end. The rest of it was very broken. Sorry about that.
Oh, sorry. Sorry, just trying to get this mic to work. Can you hear me now?
Yeah, that's clear.
Yeah, so it's just in regards to like the tobacco, would that also include vape products?
I would certainly like to look into that to confirm that. I'm not 100% sure on that. There is obviously legislation around vaping products, but I can look into that and come back to you for that, Councillor.
Yeah, no, that would be really good because it has been something that's been raised with me on a few times. There's significant issues with vaping, so it would be good to know if that is done, because obviously I know that we can do things in regards to alcohol sales and testing. It would be good if we're able to do some vape testing as well. Thanks.
If you leave that, is that Councillor Wall, is that correct?
Sorry, what was that? I didn't hear you. Yeah, it was Councillor Law, yeah.
Perfect, that's ideal. I'll look into that and I'll come back to you.
Thanks, appreciate it.
Yeah, I have one question. On page 81 of the report, it says that the person buys or attempts to buy alcohol for a child. Can you define what is meant by a child, please?
A child is anyone under the age of 18 years of age. So it's basically a proxy sale, and what we've had over that reporting period as well is we've had the campaign that ran It Will Cost You, which is a national campaign in collaboration with Police Scotland and local authorities to highlight to retailers to raise awareness of the damaging effects of and the criminal nature of buying alcohol for under 18s. And our Police Scotland Young Youth Volunteers also assisted in that and went and visited our off-sales premises, highlighting that just to make retailers aware that there is a potential, if there's young people hanging outside the premises, adults coming in to buy alcohol that might not necessarily might be buying it for these young people who refuse the sale, and they have the authority to do that. So that's been done, so it's for anyone under the age of 18.
I think I understood what you're saying there, but the clarity wasn't really good. Is there a difference legally between a child and a young person? Because I believe a young person is up to 15 years old.
There's certainly legislation. There's certainly the legislation where you get a child and then a young person, but for the purposes of this legislation, a child is anyone under the age of 18.
In this particular instance, do you know the age of the child in question?
Not for that one. I don't off the top of my head, no.
Okay. Thank you.
Hiya, it's Councillor Law again. Just to let you know, I'm going to be setting up a meeting with the Community Alcohol Partnership to see if they can get a project started down in Clackmannanshire. So our licensing officers are aware of that, and hopefully we'll get you guys involved as well.
Yeah, that would be excellent. More than happy to get involved in that, Councillor.
Councillor Keogh.
Now, is page 8 is assault and abuse of retail workers. Can you tell me the offences of these charges were used in the new law? Thanks.
Sorry, I think I might have picked it up. I'll get a bit of that feedback. I think I picked up it was assault on retail workers for the new legislation, is that correct?
Yes.
Yeah, that will be the offences there. At licensed premises there was 1, another retail premises was 9. That gives us a total of offences of 10 for that new legislation involving assault on retail workers.
Thanks.
questions? Donald?
I appreciate acoustics and great, so this is more a question to Paul under page 81. Responsible person drunk house on relevant premises, and I'm assuming that's a licence holder. Paul, what's the process in terms of, does that get reported to you and then does it get referred to us as a licensing board, or do you know anything about that particular case?
I don't know anything about the individual case, but I suppose it would depend on the status of the responsible person. It would only come to probably only have a discussion with me in relation to if the individual was a personal licence holder or premises licence holder. The responsible person definition goes beyond those that just hold a licence. Anybody that's responsible for the service of sale of alcohol within licensed premises as an employee or even as a voluntary worker could be a responsible person as well. The definition goes beyond those that hold office, if you like, or hold licences or certificates of oil and trade. So if that's just been an individual who perhaps has been left in charge in a capacity where they're responsible for making sales of alcohol, and they don't actually hold a personal licence and they're not a holder of the premises licence, and they're not an interested party, that's somebody with a financial interest, or they're not a connected person, which is somebody that's like a director of a company or something that owns a licence, then it's not necessarily a matter that would come before the licensing board or come to my attention. But I'm not, I would assume it isn't one of those people. I would expect that a discussion would have been had with me had it been one of those people. I'm sure Inspector Hattrick will be able to verify that, or you could look into it and double check.
Yeah, just on that, Paul. Certainly, if that was the case through our licensing department, we would bring that to your attention. So that would be done, that wouldn't be missed. And obviously, if it's an ongoing criminal case, it'll be sitting with the court just now. It would need to look into that one to find out exactly what premises it is, to ascertain that. But if there is anything that is a responsible, relevant person, then we would certainly make Paul and his team aware.
Hear that, it's clearly a recordable issue of concern, and that's Paul again. Is there a liaison process between you and the police on that particular issue, that if there is a case of concern, it would be referred to the licensing board?
Yes, I would say I'm in a very fortunate position to have a very good relationship with both the licensing team and the local community policing team that Inspector Hattrick heads up, I think, where we have regular discussions on licensing matters of concern, and we often reach sort of joint agreements about how best to take these matters forward. It isn't always the case that a referral to the licensing board is the best approach. For instance, I'll give you an example of this particular individual. The individual no longer works on licensed premises as a result of having been perhaps sacked as a result, and he isn't a licence holder of any description. There's absolutely no purpose in taking any further action, and that would be the course of action. Clearly, he's been prosecuted and disposed of in whatever means. I would imagine likely to be one of the alternatives to prosecution, but I think that might have been the only course of action that was potentially available or viable at the time. But yes, there's a good relationship ongoing and only that continue.
Okay, thanks, Chair.
Are there any other questions?
Inspector, I've just got one question that relates to the bylaws that I've been speaking to Councillor McCloskey in the background about the bylaws. Can I ask a question? Do you feel that the current bylaw and the wording of the current bylaw, obviously there is a great deal of concern that comes to my attention as well as it's coming to Councillor McCloskey about the amount of public drinking. And although it's not fully within my remit, I am involved in the background, and I have been involved in the background with the review of the bylaws. So the question really is the current bylaw adequate for your purposes? The current bylaw says that the officer, the police must witness the consumption of alcohol before action can be taken. There's various versions of this bylaw that exist across Scotland, including Edinburgh has a version that says that you can drink in public unless you're instructed not to do so by a police officer in uniform. So you can have your bottle of beer walking along Murrayfield unless there's disorder where you can sit in the Princes Street Gardens and have a bottle of beer, but the police have the power to prevent that. That's one of the options. I think that's less suitable for a smaller area like Clackmannanshire, more suited to city centres where events happen. The other option, of course, is that the offence is committed when somebody is found in possession of an open container in circumstances where it is likely that they intended to consume that alcohol in a public place. That seems to be a much lower threshold and a much easier, and of course we have a combination of both, where they're either seen consuming alcohol or in simple possession of an open container in circumstances where I think the wording is where it could be inferred that they intended to consume alcohol in a public place. Do you have a view on that? I mean, going forward, we are required to review the bylaws on a regular basis. We're very much due a review, fairly soon, and consultation with Police Scotland is a matter that takes place, but it would be good to have an early indication of your thoughts.
I think, obviously, as you've highlighted there, yes, police officers do need to see the individual drinking out of the alcohol to prove the offence in relation to that. And I think with the absence of like CCTV, I know in Stirling certainly most of their offences are picked up through the CCTV, proactive monitoring of CCTV and disorder within the city centre. So they probably issue, certainly from my experience when I worked in Stirling, there was a higher instances of offences being issued for drinking in public and having an open container with the presumption of drinking alcohol. That if there is reports of a lot of people in possession of alcohol in open containers and it can be reasonably inferred that they're going to drink it, then yeah, I would certainly support an amendment to that if that is at all possible.
I mean, it'll be a formal consultation process with Police Scotland when we get to the stage of doing the review anyway. It also involves a consultation with the Crown Office and Prosecution Service. The difficulty there is the question that the Crown Office are asked, is the legislation being used? Because it's only a requirement, the bylaw will only get to exist if there's evidence that the legislation is necessary and being used. I think we might struggle to argue that there's a requirement for the bylaw with only 3 cases being detected, given the amount of public drinking that's observed and complained about in the area. But again, we can deal with that when the time comes. Perhaps there is an explanation in the background about the requirement for the legislation to be changed slightly to make it easier to be used, and hopefully that will stay away the doubts that the Crown Office may have about the requirement for the legislation when the time comes.
I just want to record for the minute in the agenda, the police report refers to the period 2021 to 2022, but in actual fact it's 2022 to 2023, so I just want that clarified for the minutes. Thank you, Chair.
Okay. Are there any other questions? In that case, can we accept the Chief Constable's report? Thank you. Thank you, Inspector Patrick. Thank you for your time.
Thank you.
Okay.
Chair, can we talk to the report? Just very quickly. I'd obviously just like to thank the Police Scotland report. As in relation to the report, I think as was raised by Councillor McCluckie and the licensing officer Paul Fair, I think there is still a concern about public drinking that these licensing board need to focus upon. I think also the stats highlight the amount of abuse, not so much in licensing premises, but certainly in retail premises that are now being recorded. For instance, 28% breach of peace and 20% abuse of retail workers. That is an area of concern, particularly for off-licenses, etc. I think we as a board need to look at it. Fortunately for Clackmannanshire, the numbers are in the single figures in a lot of these cases, but I think it is for the report, and it does highlight for us as a licensing board the areas that we should be focusing upon. So thank you for that.
As I agree with figures, yes, there appear to be low. Again, this could be on the reporting side of things. Fiona, you talked about a board you're hoping to set up to discuss alcohol. Am I correct?
Yeah, I recently spoken to the alcohol partner. I can't remember what's the exact title.
With ADP, Alcohol and Drugs Partnership.
Yeah, the alcohol.
They may have a slightly different name now, but that's what they are, they're an ADP.
Yeah, so I've spoken to them, well, initial chat with them. I just need to email them now to kind of set up a meeting in regards to looking to see what we can do within Clackmannanshire. But they do kind of fund projects for young people with things to do. They also help fund kind of, I was going to say mystery shopper, but it's not mystery shopper, it's to see whether premises are selling to young people or not. So there's a variety of things that they can do. So I'm very keen to kind of set that kind of partnership up with them.
Okay. We'll certainly keep us up informed with that as it goes, and you'll set up my support or not. Okay. And we now move to item 6 on the agenda, which is a progress update on the statement of license policy.
This will, acknowledges that we've missed the publication date by a few days, but we're very close to reaching that publication. The consultation period has ended. There was very few responses. I will send out no later than the end of this week a summary of those responses. There's nothing that I can see in the responses that we received that I expect would encourage any changes to the document that went out for consultation, although that's very much a matter for you guys to consider on seeing them. But there was no major, certainly no major criticisms in any of the responses that would cause us any concern. And those criticisms that are there, quite a lot of them are not really connected with the policy process. They're generic criticisms of the licensing in Scotland rather than anything. But I'll put that, that's almost done together. We'll get that to you, and it will come along with what I suspect to be a final draft of the statement, licensing policy. Thereafter, there's a bit of proofreading to be done. The new image that we selected, which is the image of the front of Kiln Craigs, to be applied to the cover document, and thereafter we can publish it. I expect that process is fairly short, and I just hope that everybody takes the time to look over the consultation responses, the summary version of them, which is very kindly produced as I think it's a spreadsheet type document that gives all the summaries. I'll highlight those matters that I think are the ones that are most relevant, and I'll highlight some of the matters that I think are just out with the scope of the statement of licensing policy. And hopefully we'll be there relatively soon in terms of quietly in the background publishing it on our website.
The last number of responses?
No, this is not answer. There was none whatsoever to the email address from almost 200 consultations sent out, and it included the email address. There was none whatsoever. I think the online survey was completed by, I think I want to say about 14 or 16 respondees. Now that's either a really bad thing because people are suffering from online survey apathy and they can't be bothered, or it's a really good thing, and those that have consulted with a read our policy, I think it's smashing and needs no amendment. So one or other, let's go for the latter because of the lack of critical comment. There's some organisations that will have looked at it that are very, very capable of writing harsh critical comments if they think we've got it wrong, and they have in the past. And years gone by, we've been through that process where we've went, oh, okay. You know, so I wonder if we've now reached a place where we've got a solid policy, and that we've certainly in the last few years, you know, we've applied that policy in the decision-making process, which is really good to see, and it's really good for those out with the building to understand that that policy is there, and not only is it there, but we're not just playing lip service, we're actually using it in the decision-making process, and we're relying on it as part of our, you know, at our end, we're relying on it to give advice, knowing that the decisions will be based around that policy. So I think we're in a good place.
I think you're right. I mean, in the past, yes, decisions have been made, and we've been pulled up. We've been corrected, and the responses that have been brought in are really, it's really got the message across for half a hound, and I think now that we've refined it and refined over the years, and I think we're now at that stage that we are. With the benefit of the voting members, I think we've now got to that stage where we've got it right. So I'm interested just to keep an eye on where we go. So we can get this through as quick as we possibly can.
I mean, I think in reality, our publication date, our final publication date was probably yesterday. So the final publication date is probably yesterday. It would be 6 months after the election that you guys were all elected. It was on like the 6th of May and the 5th of May, somewhere around that period. So the final publication date should be, 18 months after. So we've got it. And you know, we're not by a long way the last council to publish our statement of licence and policy, our amended version. And we were quite late to the game to start the process as well. So we've caught up quite well. We've done, you know, an auditable consultation that we can show that we've asked the right people the right questions, and moving forward will be, but you know, like we said last time, we'll not need much amendment in the future unless there's significant changes in the law.
Okay, thank you for that. Any questions on the? No. I'm quite happy to note Paul's holidays. Okay, that's the case. Thank you very much for your time, ladies and gentlemen.